Imagine you're driving home late at night. The road is quiet, the headlights stretch endlessly ahead, and suddenly you see flashing red and blue lights in your rearview mirror. Your heart rate rises. You pull over. Within seconds, a police officer is walking toward your car. You roll down the window, wondering what happens next. But here's the question most drivers never ask themselves until it's too late. What are police actually allowed to do with your car? And where are the legal limits? Can they search your vehicle without permission? Can they open your trunk? Can they order you out of the car? Can they bring a K9 dog around your vehicle? And perhaps the most important question of all, what rights do you still have once the blue lights are flashing? Before we dive in, I want to ask you something. If a police officer pulled you over right now and asked to search your car, would you know what the law actually allows them to do? Think about it for a moment. And if you've ever had a traffic stop experience, good or bad, share it in the comments below. Real stories help everyone understand how these situations play out in the real world, because the truth is, millions of drivers experience police traffic stops every year. In the United States alone, researchers estimate that more than 20 million drivers are pulled over annually. Most stops are routine, but the legal boundaries that govern those moments between a driver and an officer are the result of decades of court decisions, constitutional interpretation, and evolving law enforcement practices. And when it comes to your car, the law treats vehicles very differently from houses. To understand why, we need to go back more than a century. The Fourth Amendment to the United States Constitution protects people from unreasonable searches and seizures. At its core, the amendment says that government officials generally need a warrant to search your property. A warrant requires probable cause. It requires a judge, and it requires specific legal justification. In theory, that sounds straightforward. But in practice, the courts eventually recognized something unique about automobiles. Cars move. They can disappear down the highway within seconds. And that simple fact led to one of the most important legal doctrines in American law enforcement history, the automobile exception. In 1925, the United States Supreme Court decided a case called Carroll v. United States. Federal agents suspected that a car was transporting illegal alcohol during the era of Prohibition. Without a warrant, they stopped the vehicle and searched it. The question that reached the Supreme Court was simple but profound. Did the search violate the Fourth Amendment? The court ruled that under certain conditions, police could search a vehicle without a warrant if they had probable cause to believe it contained evidence of a crime. The reasoning was based largely on mobility. A house stays where it is, but a car can be driven away. By the time an officer obtains a warrant, the evidence could be gone. That decision created what legal scholars now call the automobile exception to the warrant requirement. And nearly a century later, that principle still shapes how police interact with vehicles today. But probable cause is a critical piece of the puzzle. Probable cause means there must be a reasonable basis, supported by facts, for believing that a crime has occurred or that evidence is inside the vehicle. It cannot be a random guess. It cannot be a vague suspicion. Courts have consistently said that probable cause must be grounded in observable circumstances. For example, if an officer sees illegal substances in plain view inside the car, that may create probable cause. If a trained officer smells the odor of illegal drugs coming from the vehicle, courts have often ruled that this can justify a search. If a witness reports that a specific vehicle was involved in a crime and officers locate that vehicle shortly afterward, that information may also establish probable cause. But there is another legal concept that appears frequently during traffic stops. It's called reasonable suspicion. And it's important not to confuse the two. Reasonable suspicion is a lower legal standard than probable cause. It allows police to briefly stop or detain someone if they have specific, articulable reasons to suspect criminal activity. This standard comes from a landmark 1968 Supreme Court case called Terry v. Ohio. In that case, the court allowed police to briefly stop and question individuals based on reasonable suspicion. In the context of vehicles, reasonable suspicion often justifies the initial traffic stop. If an officer observes a traffic violation, speeding, running a red light, failing to signal, that alone usually provides legal justification for pulling a car over. Once the vehicle is stopped, however, the officer's authority is still limited. A routine traffic stop is legally similar to a temporary detention. The officer can request your driver's license. They can ask for registration and proof of insurance. They can ask certain questions related to the stop. But the stop cannot last indefinitely without justification. In a 2015 Supreme Court case called Rodriguez v. United States, the court ruled that police cannot extend a traffic stop longer than necessary just to investigate unrelated crimes unless they develop additional reasonable suspicion. In that case, an officer pulled over a driver for drifting onto the shoulder. After completing the traffic citation process, the officer kept the driver waiting in order to bring in a drug-sniffing dog. The delay lasted about 7 minutes. The Supreme Court ultimately ruled that extending the stop without additional reasonable suspicion violated the Fourth Amendment. That decision reinforced a key principle. A traffic stop must remain tied to the purpose that justified it in the first place. But here's something many drivers don't realize. Even during a routine stop, police have the legal authority to order drivers and passengers out of the vehicle. This rule comes from two major Supreme Court cases. In Pennsylvania v. Mims, decided in 1977, the court ruled that officers may order the driver to exit the vehicle during a traffic stop for officer safety reasons. Later, in Maryland v. Wilson in 1997, the court extended that authority to passengers as well. The reasoning was based on safety. Traffic stops can be unpredictable. Allowing officers to control the environment around the vehicle reduces potential risk. For many drivers, being asked to step out of the car can feel alarming, but legally, courts have generally supported this authority. Another question drivers often ask is whether police can search the entire car once a stop occurs. The answer depends heavily on circumstances. Consent is one of the most common factors. If an officer asks, "Do you mind if I take a look inside your vehicle?" and the driver says yes, that consent can legally authorize a search. Consent searches are extremely common in traffic stops, but there is something important to understand. Drivers have the legal right to refuse consent. Refusing consent does not automatically create suspicion, and officers cannot punish someone simply for declining permission. However, if officers develop probable cause through other means, they may still conduct a search under the automobile exception. There are also situations involving what the law calls a search incident to arrest. If a driver is arrested, for example due to an outstanding warrant or driving under the influence, police may be allowed to search parts of the vehicle connected to the arrest, but the scope of these searches has evolved over time. In a 2009 Supreme Court case called Arizona v. Gant, the court clarified limits on vehicle searches after arrests. The ruling stated that police may search the passenger compartment of a vehicle if the arrested person is within reaching distance of the vehicle or if officers reasonably believe evidence related to the crime of arrest might be found inside. That decision placed meaningful boundaries on automatic vehicle searches following arrests. Another important topic involves drug-sniffing dogs. Many drivers assume that bringing a K9 unit automatically allows police to search a car, but the law is slightly more nuanced. A drug-sniffing dog walking around the exterior of a vehicle during a lawful traffic stop has generally been ruled constitutional. The Supreme Court addressed this in Illinois v. Cabales in 2005. The court concluded that a dog sniff conducted during a legitimate stop does not constitute a search under the Fourth Amendment because it only reveals the presence of illegal substances. However, the timing matters. As we discussed earlier, police cannot extend a stop beyond its original purpose just to wait for a dog unless they have additional reasonable suspicion. So if a K9 unit arrives quickly while the officer is still processing the stop, courts have typically allowed the sniff. But if the stop is prolonged unnecessarily, the legality becomes more complicated. Another situation that sometimes surprises drivers involves what is known as an inventory search. When police impound a vehicle, for example after an arrest or when a car is abandoned, they may conduct an inventory search of the car's contents. The purpose is not investigative. Instead, it serves administrative and safety purposes. Officers document the contents of the vehicle to protect property and prevent claims that items were lost or stolen. Inventory searches must follow standardized department procedures. Courts have ruled that these procedures help ensure the search is not simply a disguised attempt to look for evidence. There is also the concept of plain view. If officers are lawfully present and they see illegal items clearly visible inside the vehicle, they may seize those items without a warrant. For instance, if contraband is sitting on the passenger seat or visible through the window, that observation may provide legal justification for further action. But the plain view doctrine has limits. Officers cannot manipulate objects or move things around just to create a view. The item must be immediately apparent as evidence or contraband. Now consider another situation. Imagine officers believe a car was used during a serious crime. Perhaps it was involved in a robbery. Perhaps it matches the description from a witness report. Under certain conditions, police may seize the vehicle as evidence. In some investigations, vehicles themselves become key pieces of evidence. Investigators may analyze fingerprints, DNA, or digital data from onboard systems. Modern vehicles contain more data than many people realize. Navigation history, Bluetooth connections, phone pairing records, all of these can potentially become relevant during criminal investigations. As technology evolves, legal debates surrounding vehicle data continue to develop. Some courts have addressed whether accessing certain digital information from a vehicle requires additional legal authorization, and that conversation is still unfolding in legal circles today. But beyond legal doctrine, there is another dimension worth considering: human interaction. Traffic stops are one of the most common points of contact between citizens and law enforcement. Every stop involves two people, sometimes more, who may not know each other, may not trust each other, and may each feel uncertain about what will happen next. For officers, traffic stops carry real risks. Historically, many assaults on police have occurred during roadside encounters. For drivers, the experience can also feel stressful or intimidating. Understanding the legal framework helps reduce uncertainty for everyone involved. When drivers know what officers are legally allowed to do and officers respect the boundaries set by law, those encounters are more likely to remain calm and predictable. It's also important to recognize that legal rules sometimes evolve. Supreme Court decisions refine interpretations. State courts may apply additional protections. State legislatures may create new statutes governing police conduct during traffic stops. In other words, the law surrounding vehicle searches is not frozen in time. It continues to develop as courts evaluate new technologies, new policing practices, and new constitutional questions. And that brings us back to the moment where we started: the flashing lights in the mirror, the quiet stretch of road, the officer approaching the window. That moment may last only a few minutes, but within those minutes, more than a century of constitutional law quietly shapes what can and cannot happen. Police have authority, but that authority exists within boundaries. The automobile exception, probable cause, reasonable suspicion, consent, plain view, inventory procedures. Each of these concepts forms part of the legal framework governing your car. So the next time you hear about a traffic stop on the news or see flashing lights on the highway, remember something important. Those encounters are not simply random moments. They are guided by legal principles built through decades of court decisions and constitutional interpretation. And perhaps the most valuable question every driver can ask is not just what police are allowed to do, but whether we truly understand the rights and responsibilities that exist on both sides of the window. What do you think about these legal boundaries? Do they strike the right balance between public safety and personal privacy, or should the rules surrounding vehicle searches be stricter? Share your thoughts and experiences in the comments. Because understanding the law is not just for lawyers. On the road, it can affect every single driver.